A special thank you to each of our subscribers who make this channel possible. Here's today's story. In a significant ruling that has stirred controversy across the nation, a federal judge in Washington, D.C., has denied a motion by far-left immigrant advocacy groups aimed at blocking the Internal Revenue Service, IRS, from sharing taxpayer information with Immigration and Customs Enforcement, IC. This decision, made by U.S. District Judge Dabney L. Friedrich on Monday, allows the IRS to share taxpayer address information with ICE for criminal immigration investigations. The case, known as Centro de Trabajadores Unidos et al. V. Scott Besson et al., was brought forth by several immigrant advocacy organizations, including Immigrant Solidarity DuPage and Somos Un Pueblo Unido. These groups argued that the IRS's plan to share data with the Department of Homeland Security, DHS, was illegal, arbitrary, and violated the trust of immigrants. However, Judge Friedrich ruled that the IRS is legally authorized to provide such information under Section 6103 I-2 of the Internal Revenue Code, which permits federal agencies to request and receive tax return information in connection with criminal investigations. The judge emphasized that the IRS must comply with these requests if proper procedures are followed, stating, "To summarize, the IRS must disclose limited taxpayer identity information, e.g., the taxpayer's name and address, to assist another agency in criminal investigations and proceedings." This ruling comes on the heels of a Memorandum of Understanding signed between the IRS and DHS on April 7th, which allows ICE to formally request addresses of individuals under criminal investigation. Critics, particularly those aligned with Democratic causes, expressed outrage over the ruling, claiming that immigrant taxpayers have long been assured their data would not be used for immigration enforcement. However, Judge Friedrich found no merit in this assertion, stating that the IRS's interpretation of its authority aligns with long-standing statutory provisions. The plaintiffs attempted to argue that the IRS data could be used for civil deportation actions rather than criminal investigations, but Judge Friedrich swiftly dismissed this claim, reiterating that the memorandum specifically limits disclosures to criminal investigations. In her ruling, she stated, "The Memorandum of Understanding between the IRS and DHS does not violate the Internal Revenue Code. The plain language of 26 U.S.C. Section 6103 I-2 mandates disclosure under the specific circumstances and preconditions outlined in the memorandum." The ruling has ignited a heated debate about privacy rights and the implications for immigrant communities. Many worry that this collaboration between the IRS and ICE could deter immigrants from filing taxes, fearing that their information could be used against them. Tom Bowman, policy counsel for the Center for Democracy and Technology, warned that disclosing immigrant tax records to DHS could discourage tax compliance among immigrant communities, weaken contributions to essential public programs, and increase burdens for U.S. citizens and non-immigrant taxpayers. The IRS has faced internal turmoil regarding the administration's push to broaden access to taxpayer information, with previous acting commissioners resigning amid backlash over controversial data sharing arrangements. The Treasury Department defended the IRS-ICE collaboration, stating it supports President Trump's broader immigration enforcement strategy, which has included mass deportations and workplace raids. As this situation unfolds, it remains to be seen how this ruling will impact immigrant communities across the country and whether further legal challenges will arise in response to the court's decision. That's all for this story. We upload videos every day covering many different subjects, so hit that subscribe button to stay informed. Thanks for watching.